Attendez qui met les phones là, whether on silent. What's your camera? I'm about to go and I camera.
As it is in the court, Your Worship, I place before the court case 20/497/24, the State versus Selina Charlotta. The matter is heard before the Magistrate's Court on the 12th of August 2024. I am Advocate Jaden Nyssen from the Office of the Director of Public Prosecutions in Bloemfontein. I am being assisted by Advocate Sandra Free. And also to my right is the investigating officer, Captain Carlitz of the Hawks. I shall give an opportunity for my colleagues to just place them on the record.
May it please this Honourable Court, Your Worship, I am Louisa Makapela. I appear on instruction from Morakia Attorneys Incorporated, and I appear on behalf of the applicant, accused number 17.
Can I just ask you to spell your surname?
M-A-K-A-P-E-L-A.
Thank you.
Thank you, Your Worship.
Thank you, Your Worship. Your Worship will notice that I attached to the J15 a copy of the indictment in the High Court, that being the indictment on which the accused will appear in the High Court shortly hereafter, sometime within this month. Your Worship will also see that the accused is accused 17, or will be accused 17 in the High Court. For purposes of this bail application, I also hand up a order from the Department of State of the United States, signed by the Deputy Secretary of State of the United States, indicating which charges the accused or applicant has been extradited for. We will address this issue in much more detail later on, but there was an extradition application to the US for the extradition of this applicant, which was granted earlier in this year. Without preempting the application as such, I wish to point out that the courts in the US and the Secretary of State granted the extradition of this applicant on counts 3, 4, 5, and 6 of the indictment, as well as all the corruption charges against her, as well as the alternatives thereto. Those counts counts 15 to 19 of the indictment, where she is charged together with the former Premier Ace Magashule. That is the introductory part. Your Worship, I understand that my colleagues intend to bring an application today for the applicant to be released on bail. For the record, the State opposes this application.
sir just address me on the schedule that these offences fall under?
Indeed, Your Worship. I understand that we are adhering, the state and the defence, that this constitutes Schedule 5 offences. As it pleases.
Thank you, Your Worship. Your Worship, as previously indicated by my colleague, this is a bail application in terms of Section 60, Sub 11 of the Criminal Procedure Act, as this is a Schedule 5 offence. We will be bringing the evidence on by way of affidavit and will not be leading any oral or viva voce evidence. The affidavit has already been signed and attested to by Ms. Cholota. Could I please have permission to refer to her as Ms. Cholota, Your Worship? I will struggle to keep going from applicant to accused.
Yes, you may proceed.
Thank you. If I may please get Your Worship's permission to read the affidavit into the record.
Yes, you may proceed. Thank you.
Okay. I, the undersigned Nomalanga Murwadi Selina Cholota, do hereby make oath and state I am an adult female currently being held at Baines-Flay, Bloemfontein. I am a South African citizen with identity number 870210093408. I am the applicant herein and have been informed that I am charged with fraud, corruption, and money laundering. I am advised that these offences fall under Schedule 5 offences under the Criminal Procedure Act 51 of 1977, hereinafter referred to as the CPA. In this affidavit, I intend on adducing evidence before this honourable court that will prove that it is in the interest of justice that I be released on bail. Further to the above, I wish to adduce evidence to show that I will attend all relevant court hearings in my matter and will not flee the country or pose a flight risk, nor will I commit any crimes or intimidate the witnesses in this matter. In proving and showing this evidence, I submit that it is in the interests of justice that I be released from detention at the earliest possible opportunity. While I appreciate the seriousness of the charges that have been leveled against me, I wish to state right at the outset that I am not guilty of any charges against me. I verily believe that the state will not be able to present any objective facts or provide any evidence that will prove that I engaged in fraud, corruption, or money laundering. I have deposed to this affidavit of my own free will and have not in any way been unduly influenced to depose thereto. The facts herein contained, save where expressly indicated to the contrary, are within my own personal knowledge and belief and are both true and correct. Where I make any statements of a legal nature, I do so on the advice of my legal representatives, which advice I accept as correct. First heading, Act application in terms of the Criminal Procedure Act. The purpose of this affidavit is to provide the above honourable court with my personal circumstances and to address the allegations levelled against me, as well as to address the factors to be considered by the above honourable court in respect of my bail application as contained in the Criminal Procedure Act. I have been advised and understand that having been charged with a Schedule 5 offence, I bear the onus to show that it is in the interest of justice that I be released on bail. I will herein below place factors before the honourable court to show that the interests of justice permit my release on bail. Second heading, add personal circumstances and current status. I am 37 years of age and was born in Parys, Free State. I have resided in the Republic of South Africa my entire life. Although neither of my parents are still alive, step-parents, my half-sister, and extended family members, all of whom live in and around Bloemfontein and Parys. Prior to departing for the United States for my studies, I resided at my property in 10233 Graslands, Bloemspruit Street, Bloemfontein. I intend to live with my step-parents upon my release on bail at 43 Weirda Crescent, Ace Bloemfontein. I own an immovable piece of property situated at 10233 Graslands, Bloemspruit Street, Bloemfontein. I submit that the property is situated within this Honourable Court's jurisdiction. For ease of reference, I attach a proof marked Annexure NC1. I do not have any friends beyond the borders of South Africa. I had one friend in Baltimore, Maryland, with whom I studied with, but since my arrest and detention pending my extradition and subsequent extradition back to South Africa, I have lost all contact with her. I confirm I no longer possess any passport or any form of travel documents. I was transported back to South Africa on emergency travel documents. My passport was left behind in Baltimore, Maryland, and has not been in my possession since my arrest and detention in April 2024. I presently reside in the address mentioned in paragraph 11 in this affidavit. These premises belong to my step-parents, who have been my parental figures since the passing of my parents. The above address falls within this Honourable Court's jurisdiction and was verified by Captain Benjamin Kalitz on Sunday, 11 August 2024. I am currently unemployed. At all times that I was employed, I was employed within the Free State Provincial Government and in Bloemfontein. The only relative beyond South African borders is my 14-year-old son, who I transported to Nigeria so that he could go and live with his father, with whom I am no longer in a relationship. His father is currently making arrangements for my son's return to South Africa now that I have been transported back to South Africa. I have never been charged with or convicted of any criminal offence either in the Republic of South Africa or elsewhere. There are no outstanding cases other than the present being investigated against me by the South African Police Services. Third heading, ad merits. My legal representatives have explained the relevant provisions of the Criminal Procedure Act to me. I respectfully make the following submissions in this regard. I have been informed that I am accused of having committed the offences of fraud, corruption, and money laundering. I deny the aforesaid allegations in the strongest terms. I here and below fully canvass the circumstances which support the aforesaid denial. On the outset, I wish to state that I am confident that I will not be found guilty on the charges levelled against me, and that the case against me is inherently weak for the following reasons. It is well known that I was a state witness in this matter following my oral testimony at the State Capture/Zondo Commission on 19 December 2019. I was not charged with corruption, money laundering, and fraud with my co-accused, as there was no evidence linking me at all to the crimes my co-accused were charged with. I was informed by the investigators that I would be questioned about the same matters canvassed in the State Capture/Zondo Commission when they told me I was a state witness on 16 November 2020 via email. On or about 21 and 22 September 2021, I was interviewed by the investigators in Baltimore, Maryland and Washington, D.C. in respect of the asbestos project. The investigators threatened to charge me with the same charges as my co-accused if I did not cooperate with them. There is no evidence to show that I never cooperated with the investigators. They felt that I had not provided them with the information that they were looking for and decided to charge me with fraud, corruption, and money laundering. The charges against me do not arise out of any factual and objective evidence, but from a sense of wanting to punish me for not cooperating with investigators and the prosecutors in the matter. I was never implicated in any wrongdoing related to the asbestos project in all of the investigations undertaken by the various state agencies, including the State Capture Commission, the Public Protector, the Auditor General, and the Special Investigating Unit, the SIU. The law requires that the state prove the case against me beyond reasonable doubt. I am certain that it will fail to do so, as it has no evidence that links me to any fraud, corruption, or money laundering. I thus intend to plead not guilty in the envisaged trial. Fourth heading, at flight risk. I will stand my trial and attend all the required dates for the hearings, as I am determined to prove my innocence and prove the unconstitutionality of my arrest and the charges against me. I have faith in and trust in the South African legal system and the Constitution that forms part of its foundational values. The facts will show that I am not guilty of the charges leveled against me and that I never should have been involved by the investigators in this case. I am determined to show the unconstitutional manner in which the state has treated me and leveled charges against me. I am determined to clear my tarnished reputation and restore my good name, and for that reason, I certainly have no desire to evade justice. In any case, that is also rendered impossible due to the fact that I have no valid passport or travel documents. In order to persuade the above honorable court that it would be in the interest of justice to release me on bail, I provide the following additional facts. Fifth heading, add additional facts. I was arrested in the United States on or about 12 April 2024 at the request of the South African government and remained in detention from that date until the present date. I was first detained in Baltimore, Maryland, and then on 1 August 2024, I was moved to a prison in New Jersey, USA. On 8 August, I was detained at Brooklyn Police Station in Pretoria, whereafter I was transported to Bains-Vlei in Bloemfontein and was detained in that prison over the weekend until today. This means that I have been imprisoned and detained in jail for almost 4 months. There is not a single one of my co-accused that has spent longer than even a day in prison. They have all had their freedom and liberty respected by the state and have been released promptly on bail. I am advised that it is crucial that this honorable court consider the rights to human dignity and equality enshrined in sections 9 and 10 of the Constitution in this regard, and afford me the right to be treated equally to my co-accused and other arrested persons who are released on bail at the earliest possible opportunity. I am further advised that keeping me in prison under detention for any longer than is necessary is prejudicial to my constitutional right under Section 12, subsection 1A of the Constitution, which guarantees everyone's right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause. I am also advised that liberty is qualified and circumscribed by Section 35(1)(f) of the Constitution, which reads, "Everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interests of justice permit, subject to reasonable conditions." It is not in the interest of justice that I remain in detention without just cause. I submit that the state has had ample opportunity to gather all the relevant information they were required to and to adequately plan for any case to oppose my bail to an extent that they wanted to do so. As previously stated, I have no previous convictions and I have not been released on bail pending any trial. I'm not intending to apply for any travel documents pending the finalization of these proceedings. I pose absolutely no threat to the public and I am not predisposed to violence. I submit that my release will not disturb the public order or undermine the proper functioning of the criminal justice system, including the bail system. Since my arrest on 12 April 2024, I have fully cooperated with the law enforcement agencies and authorities and all requests made by the state and SABC representatives. I will not attempt to evade trial if I am released on bail. Bearing the above in mind, together with my submissions contained in this affidavit, I humbly request that this honorable court consider setting bail in an amount of 2,500 rands. Should this honorable court set bail in a higher amount than what has been previously requested immediately above, I submit that I will be able to raise the necessary funds to facilitate the payment of the set bail amount. Sixth heading, General. I humbly submit that all my family, cultural, and property ties are within the Free State Province and within the jurisdictional area of this honorable court. I will comply with any further reasonable conditions as the above honorable court may wish to impose on bail. I accordingly submit that it would be in the interest of justice to release me on bail in a reasonable amount with reasonable conditions. Regard being had to the contents of this affidavit, I have been advised to and respectfully submit that, having been given a reasonable opportunity to do so, I have adduced evidence in this affidavit to satisfy this honourable court that it is in the interest of justice that I be released on bail as envisaged by the provisions of the Criminal Procedure Act 51 of 1977. Wherefore, it is submitted that I have made out a case for my release on bail. Signed in Bloemfontein, 12th day of August 2024, Nomalanga, Murwaji Selina, Choloka. That is the applicant's evidence on affidavit, Your Worship. I wish to hand up a signed copy of the affidavit.
Thank you. Ms. Charlotte, do you confirm?
Yes, I do confirm, Your Honor. Thank you.
You confirm that this is your statement and that it is also correctly done?
Yes, I do confirm that this is my statement.
Thank you very much. I'll receive if it's marked as Exhibit B, because Exhibit A is the document that was handed in once earlier.
As it pleases.
Is that your application? Do you close your application?
I confirm that we close our case. Your Worship.
Thank you.
If I may confer with my attorneys before I do.
Please do that.
Could I confirm that we do have a right to reply to the response from the state, Your Worship?
Yes, you will.
As the court pleases. Then that is the case of the applicant.
Thank you, Your Worship. Your Worship, I wish to place on record that this affidavit was served, or rather handed to us, around about 9 o'clock this morning, for purposes of the opposition of this application and the interest of justice. The state requests a remand to tomorrow in terms of Section 50, subsection 6 of the Criminal Procedure Act. I reiterate, we don't apply for instance, a week or less, as is allowed in the subsection, but only for 1 day. To give us opportunity to answer to each and every of these aversions, may I say that I've attempted to peruse it quickly, and as far as I can ascertain, we disagree with the better part of 90% of what is alleged here. So the state needs to file a proper and comprehensive sworn affidavit by the investigating officer, and I shall make my final decision pertaining to whether he will testify or not, or whether we shall rely on the affidavit by him before we get to court tomorrow. It will probably be the latter. May I say that we have started compiling papers in this regard. It is not a question of the state having done nothing. Since it came to our knowledge that the accused will be extradited, so it's just a question of finalising the opposition to the bail application, if it is.
Thank you, Your Worship. Your Worship, we start first by quoting, or rather referring to, the relevant provision in the Constitution that applies to bail applications. It requires that an accused be released lest they be arbitrarily held. Arbitrary in that without just cause. There may be reasons that the state may have to keep the accused or the applicant overnight. We state that that is a further violation of her rights because she deserves not to be detained for a second longer. As things currently stand on the 12th of August, she has been detained uninterrupted for a period of 4 months. That is 80 times longer than any of her co-accused, and which is why we were emphatic on quoting the section on equality, which is to say, if her co-accused were able to be released on bail and the state was able to oppose their bails and have its case ready on the day that they applied for bail, then there is no reason that Ms. Cholota should spend even an hour longer than she needs to. The second point that is raised by the state, Your Worship, that we wish to oppose, or rather that we wish to respond to, the state knew as far back as July that Ms. Cholota had been extradited, and that is being generous with the time, because if memory serves me correctly, it was May that the decision was made. No, it was June, my apologies, it was June, and then the decision was referred to the Secretary of State, and that is when submissions were asked, but the decision in and of itself was made towards the end of July. So from the end of July, they have known that she would be back, that any and every opposition that they would have to make, there's nothing that we have raised in the papers that is new that the state has not known, nor that we hadn't raised in prior conversations with the state. But most importantly, Your Worship, we had a conversation telephonically with the state prosecutor, Mr. Donation, and on Friday. And he, as far back as then, confirmed that they were going to be opposing bail. And so he could have prepared himself, interviewed the investigating officer. That did not warrant sight of our bail application. And he could have had his case ready so that we are able to proceed. But that was not the case. And so our submission is that it cannot possibly be said that his wanting more time so that he can go and do his job is sufficient to justify Ms. Cholota's arbitrary detention for longer than need be. Now, to the regular person, perhaps a night in jail is nothing less than a night in jail. But for someone who has spent 4 months in prison, an hour longer than need be in jail is too much. And so we really implore this court to consider itself bound by the Constitution, and also to consider that the interests of justice have never been more necessary to call in than in this matter. There is no reason that Ms. Cholota should be in jail, and there's no reason that she should be in jail overnight so that the state prosecutor can do a job that he has known days in advance that he needed to do. The submission that we need to file a proper and final affidavit and that we need an opportunity to reply simply cannot stand. It is now 10:30. This can be done towards the end of the day. They can come back with, if in fact his submission is correct, that they have been working on this, then 4 hours, 5 hours should be sufficient for them to draw up an answer to our papers and return so that this matter can be finalized. We simply cannot have it be, milady, Your Worship, my apologies. We simply cannot have it be that the state, over and above all of the disregarding of Ms. Cholota's constitutional rights, be so used to it that even now they insist on disregarding her rights. There isn't a single of the 17 other accused that has spent a night in jail, that has had their bail application postponed. Every single one of them came to this court and was granted bail. There's no reason, just cause. So the reason that Ms. Advocate Donation is purporting to advance is simply not sufficient in our view to justify Ms. Cholota going back down in those cells and going back to the jailhouse for yet another night. And we do not even know that tomorrow it might be finalized, as he says. Perhaps tomorrow, once he has decided, as he said, whether he will adduce viva voce evidence or oral testimony, if it will not again be postponed for another day. And so we cannot trust that the rights of Ms. Cholota in this instance could be said to call in the interest of justice. We simply cannot. The case law is replete with examples of the Constitutional Court time and time again insisting that a person cannot be detained arbitrarily without just cause. To detain her for a single night longer than she should, at the behest of Advocate Donation, simply does not stand in our view. That is our submission on that regard. We are of the view that if the state indeed has been dealing with this case since June, July, as they say, then 5 hours should be sufficient for them to come back and respond to an 11-page affidavit. We do not accept the request for the matter to be postponed and for bail to be heard tomorrow. Thank you, Your Worship.
You want to say anything?
Yes, thank you, Your Worship. Why my colleague makes it personal and saying it is at the behest of Advocate Nason that the applicant is kept in custody, that is of course not correct. It's in the interest of justice. There's nothing personal. Just a few aspects. With all due respect, if the defense thinks that they can dump an affidavit on the state around about 9 o'clock when the court should have started already, and expect the state to roll over and concede to everything that they ask, to force the state and by implication the court to hear a bail application basically on an urgent basis, they are sorely mistaken with all due respect. I shall point out, or we shall point out in the sworn affidavit that this applicant has been delaying this whole matter for more than 2 years. We shall point out in the affidavit that at the beginning of this year there was an undertaking in the High Court that she would surrender herself. That changed. We shall point out in the sworn affidavit that she brought an application before the Constitutional Court in South Africa to prohibit the state to prosecute her. That application has been dismissed by the Constitutional Court while we're now speaking about constitutional rights and so forth and so forth. It is just plain and simple in the interest of justice that the state get the opportunity to properly prepare. And it's not only for the state. I handed in an indictment of 104 pages. And with all due respect, Your Worship, I humbly request the court to at least read the preamble and the summary of substantial facts, which, and of course the charges relating to this accused, which is a lot. And it is quite complicated allegations, so I assume that the court at least will also need time to look at the substance of all these charges against the accused. The state still requests the remand until tomorrow. Thank you.
Thank you. I've listened to both parties, and yes, we do expect of the state to be ready after all this time with most of the affidavit, but it is also correct that the lengthy affidavit was read into the record today, which the state did not have access to before today at 9 o'clock. So in all fairness to the state, I will allow this postponement until tomorrow morning at 9 o'clock, so that we can then continue with the application. I don't want the state to start with something and then they can ask another postponement because they're not completely ready. Let's rather give them the hours today to continue, prepare, and then come back at 9 o'clock.
As it pleases the court. I've been informed by the investigating officer to request the Honourable Court to make an order that the accused be kept at Banesvlei police station, or else she will have to be transported to Kroonstad, female prison, which is not conducive to our proceedings tomorrow as it is.
Any objection by the defence?
We do not have any objection, Your Worship.
is postponed until tomorrow, that's the 13th of August, 2024, for further evidence in this file application. He will remain in custody and as requested at the Baines Flight Station at the cells. It is easier and more convenient because if you have to be taken to court, it is a long drive there and back in the morning, which may cause your application to start late. So we want to start at night in custody until then. Thank you.
As court pieces, that is our rule.
All right,
Very